agenda, I had asked you to study the whole charge sheet and to tell us whether or not there is an allegation that Advocate Chauke sought improperly to get Advocate Mlotshwa to sign the indictment.
There isn't.
Thank you very much. Now, can I ask you about 3.1.1.2? It says that presumably you recommended to the then acting National Director of Public Prosecution, Advocate Nomgcobo Jiba, the application for issuing a racketeering authorization in terms of Section 2.4 of the Poker Act, whereas there was no evidence justifying the institution of racketeering charges against the accused. Now, the recommendation that is referenced there, is it the document we went through repeatedly, which is PP'd by Advocate Chauke? I just want to get the...
Please repeat your question, Council.
Yes, or maybe what is better is that I must just refer to the document
I think
itself.
that will be helpful.
Yes. My Leonard Jr. will find it now. The question really is this. You had a discussion with Madam Ramachakha about whether or not Advocate Chauke's recommendation was PP'd or signed by him. I just want to know if the charge is referring to that particular document.
That is certainly one of the documents it will be referring to. I'm not sure if it's the only one.
All right, let me find the specific document right now, because you might help us on that. But the second question I have, I'll come back to this as soon as we find it.
I think I should try to find it as well. Chairperson, if I can get some assistance so that we have the documents ready through you, Chairperson. I'm not sure where these
Indeed.
documents are.
Yes, Madam. Advocate Hali, where's your junior? She doesn't appear to be here.
They're trying to find their documents.
She's trying to find the document.
Yes.
But I will obtain that document because I think that's
No, my junior was quick on the mark. It's LO 00780.
M
LO
LO
00780.
80.
Yes.
Is that an internal memo from Advocate Nokumashilu to Advocate Jiba?
Yes, Madam Chair.
Yes, thank you.
Yes. Dated the 15th of August, 2012. Now, the reason I ask...
May we wait for Advocate Batoy? Do you have it?
I do have it now.
You have it,
Yes.
Madam.
Now, the reason I ask Advocate Batoy is that it is the only document I could find that uses the word, I have perused the documents and recommend the application. And when you look at what is recommended, is at 1.3 are the draft authorizations for Section 2.1E and 2.1F of POCA. Is that what you are referring to in 3.1.1.2?
This is definitely what we are referring to.
All right, that's fine. We can note that that's the document you are referring to.
I didn't say it's the only document, but it
Well,
is a document that
show
we're
us
referring to.
any other document.
I'm
that-
not sure if it's shown to me, then I might be able to comment on it.
Well, in your evidence in chief, you did not make reference to any other document. In our own search, we did not find any other document where there is a recommendation for the signature of the racketeering authorization,
Mhm.
other than that document that involves Advocate Chauke.
I think there's another document that's prepared in his name, but is not signed by him.
Yes, exactly. That is the only document that is signed. I know what I'm asking you.
Mhm.
So I come back to my question. This is the only document we could find that is signed by Advocate Chauke.
Relating to the racketeering authorization.
Well, that is obvious, Advocate Batohi, please, because I am talking about 3.1.1.2, which is about the racketeering authorization.
No, with all due respect, I don't want to take, things may not be that obvious. So I want to make sure when I answer, we're
All
clear
right,
about what
I
I'm answering.
apologize. Yes, the answer is yes.
So in this case, it does relate to the authorizations for racketeering. That's correct.
Yes. Well, let's make this clear because I Advocate Chauke, which reference authorization under Section 2, subsection 4 of POCA. Is that correct?
That's my recollection.
Yes. Thank you very much. Now, with staying on 3.1.1.2, that charge has nothing to do with the predicate offenses independently. I understand that predicate offenses are part of POCA, but it has nothing to do with the separate charges. It's limited only to Section 2.4. Is that correct?
That's correct.
Yes, thank you. Now, if we could also analyze 3.1.1.3.
Mhm.
It says Mr. Chauke sought to defend the institution of the aforementioned racketeering charges in the review proceedings brought by Major General Boysen to have the said racketeering charges set aside, and that he finalized the answering affidavit of the then acting National Director of Public Prosecutions, Advocate Nomgcobo Jiba, in the Boysen review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, is it the case of the NPA that when it says Mr. Chauke defended those proceedings, it is referring to the role he played in the preparation of the answering affidavit of Advocate Jiba?
It is definitely that.
Yes. Yes, but there is nothing else. It is only that.
I'll have to think about the evidence carefully. I've laid a lot of evidence, and I don't want to concede that it's only this if I haven't really carefully considered what the evidence is. So I need to think about this.
You know, Advocate Batoy, you have spoken in this inquiry, I think, for 12 days. For you to say you still have to think carefully about the evidence really sends a negative signal.
That's your opinion, Advocate.
But I presume you have thought about the evidence you've given for the last 12 days.
I certainly, it's been something that has been consumed me for the past 12 days, but there's a lot of evidence. So I need to be careful when I say it's the only evidence because there's a line, so I need to think about this. I don't want to concede and then there's something else. So I should be allowed to think about this carefully.
I'm not asking you not to think about it, but I am putting to you that before you gave the evidence, you should have thought about it. You cannot be asking to think about it during cross-examination.
That's your view. I'm going to think about it anyway before I answer your question. So this is definitely one of the aspects of his defending the institution of racketeering. I'm trying to think about whether there's anything more in this respect.
Can I also assist you? The charge itself limits the factual basis to the finalization of the answering affidavit. It does not include any other thing.
If I may on that point say that the chapeau to these charges, if we want to call them charges, for want of a better word, states at 3.1, his direct or indirect conduct should be the direct or indirect conduct of Advocate Chauke relating to his fitness and propriety to hold office based on information, including but not limited to the matters related to the following allegations. And my point is that in as much as these attempt to set out or do set out conduct of Advocate Chauke in this context, it is not limited to this.
Well, this is what I'm debating with you, Advocate Batoyi. What is the indirect conduct that is referenced?
So I need to think about all the evidence that I've provided thus far.
But I'm asking you, I'm putting to you that the charge is 3.1.1.3. You are saying in answer to me, no, look at indirect evidence. And I'm asking you, what is the indirect evidence?
With all due respect, I didn't say look at indirect evidence. What I said is that I was reading out the chapeau, and I said it states including but not limited to matters related to the following allegations. My point being not about indirect conduct, but about the fact that the allegations are not limited to what is set out in 3.1.1.1 until 3.1.1.5. That
Now,
was the
what
point.
are the other allegations that are not included? What we cannot have.
For example, the allegations relating to the signing of the Advocate Chauke's request for Advocate Malochwa to sign the indictment,
No,
that should
please.
have been included here.
Please, Advocate Batoyi, we are at 3.1.1.3. At the stage at which Major General Boyson is in court, the NDPP is filing an answering affidavit. The charge tells us that its scope is the finalization of the answering affidavit. You are resisting my submission to you that that scope is limited. You're saying it's unlimited. I'm asking you, what are the other facts that support the defense of that review application?
I don't know for now if there are any other facts.
Thank you very much. Can we then go to a second aspect of that charge? You know, the last line, which starts with of racketeering charges against the accused.
I beg your pardon, Counsel, to interpose. The question that you asked Advocate Batoyi in relation to the specific aspect, that is the scope of 3.1.3. Might we look at page 66 of the affidavit? It might help us. Page 66 of the record that contains your affidavit, paragraph 156. You have it, Advocate Batoyi?
In a moment, Chairperson. Yes, I'm there.
Paragraph 156 of your affidavit gives us the essence of the allegations against Advocate Chauke. And for the purpose of the last question by Counsel, we may look at 156.4. You remember that?
I do,
You
Chairperson.
see that?
Mhm.
And by mere looking at paragraph 156, giving us the essence
Mhm.
of those allegations against him, that is Advocate Chauke, the essence is there.
Mhm.
And it includes 1564 to the extent that he settled the affidavit of Advocate Jiba.
Mhm.
And there appears to be nothing more in that paragraph 156
Mhm.
as regards the question that is put to you.
Mhm.
Am I correct?
This is the essence of the allegations, indeed, Chairperson, which is summarized in this paragraph.
I am specifically referring to 156.4
Mhm.
as regards the question that is put to you regarding the conduct of the alleged conduct of Advocate Chauke in settling the answering affidavit of Advocate Jiba.
Mhm.
And I'm asking, is it correct that there is nothing more to this paragraph 156.4 in this affidavit? Your affidavit?
Chairperson, I'm not sure if there's nothing more because this was, as I said, summarizing the essence of the charges. I don't know if this is dealt with anywhere else in the affidavit.
This is your affidavit, counsel. With the greatest of respect to you, you should be able to help us because it is your testimony.
Mhm.
You should know this affidavit better than us. It is your affidavit under oath.
Mhm.
Otherwise, you're going to have to adjourn again and read this affidavit so that we ascertain whether there is any other part in your affidavit that makes reference to the further conduct of Advocate Chauke that is impugned.
I'm trying to go through the affidavit quickly, Chairperson, to the other sections and look at whether it was covered, because I know when we were drafting it, we dealt with the allegations and then we summarized the essence. So I suspect that it would be covered somewhere else as well. Um,
I request the lady next to you and the junior counsel over there, if there is anything else that you might have picked that may be of help to Advocate Batoi, don't hesitate to bring it to her attention.
yes, if they could check in the electronic version, it will be easier perhaps.
You may quickly, counsel, look at the electronic version.
I'm advised 146 might be applicable. 180. 180. 180.
I think 146 is just a replica of what is stated in 156, the essence
Okay,
of the two.
146.
146 reads, in response,
Mhm.
Jiba deposed to an answering affidavit. This affidavit was, according to Advocate Chauke himself, finalized by him.
Mhm.
And that reiterates what appears as an essence at paragraph 1564.
That's correct, Chairperson. I'm checking 180 as well. Mm. 180.8, I think, Chairperson. Are those the only places? Those are the only three places. Okay. Those are the only other places that they can pick up electronically, Chairperson. And so we should accept that those are the only places where this is mentioned.
One
0.8.1.
8, page 76 of your affidavit. The heading there read, there is prima facie evidence that Advocate Chauke was complicit in the fraud and perjury charges leveled against him. And 188.1 reads, Chauke deposed to a confirmatory affidavit in the GCB case, where he confirmed that he finalized Advocate Jiba's answering affidavit before Grovan's judgment gave rise to the fraud and perjury charges against Advocate Jiba. I suppose the point that you are referring to is the first line of 180.8.1. That again, and not necessarily so, that he deposed to a confirmatory affidavit, supposedly following the answering affidavit that you relied upon earlier. Is it a different matter?
No, it's the same matter, Chairperson.
Thank you.
Thank you, Madam Chair. I think could we just come back to this topic because I'm just not sure if there is any difference. Let's start with 3.1.1.3, which is the charge. Okay. Now the charge says you sought to defend the institution of the aforementioned racketeering charges in the review proceedings brought by Major General Boysen to have the said racketeering charges set aside, and that you finalized the answering affidavit of the then acting national director, Advocate Nomgcobo Jiba, in the Boysen review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of the racketeering charges against the accused. Now, my question to you was, my reading of this charge is that the scope of that charge is limited to the role Mr. Chauke played in the preparation of the answering affidavit of Advocate Jiba. Your answer was no, it may be broader than that. That's where the discussion started. Now, the chair then intervened to say perhaps your affidavit can shed more light. Now, let's look at each of the paragraphs you've now cited, starting with 146. Now, paragraph 146 reads, in response, Jiba deposed to an answering affidavit. This affidavit was, according to Advocate Chauke himself, finalized by him. Would you accept that that is the same as 3.1.1.3? It does not add any additional facts.
That's correct.
Yes. Now let's go to paragraph 156. Now, paragraph 156, the relevant part, as pointed out by the chair, is 156.4, which says he settled the affidavit of Jiba and the allegations contained in Jiba's affidavit were found to be false, and as such, he had made himself party to those false allegations. But the conduct is still the same. It's the role he played in the finalization of the answering affidavit. Is that correct?
That's correct.
And then the last one is paragraph 180.8.1, which reads, Chauke deposed to a confirmatory, should be a confirmatory affidavit, in the GCB case where he confirmed that he finalized Advocate Jiba's answering affidavit before Govan J. Govan's judgment gave rise to the fraud and perjury charges against Advocate Jiba. Again, would you accept that the conduct is still the same? It's the role of Mr. Chauke in the finalization of the affidavit by Advocate Jiba.
That's correct.
Yes. We can then come back to where I started. There is no other case that Advocate Chauke is other than the role that he played in the finalization of the answering affidavit of Advocate Jiba. Is that not correct?
Yes, let me just say that there's different actions that Advocate Chauke took in this process. For example, liaising with the team and Advocate Hodes, but it's all in relation to the finalization of this affidavit.
Yes, but I've never asked you about those sub-steps. I asked you that the conduct you are worried about is the role he played in the finalization of the answering affidavit. Obviously, he did many things, including signing a confirmatory affidavit. But what I want us to agree about is that that charge, the scope of it, is limited to the role he played in the preparation of the answering affidavit.
I'm trying to answer this set in a way that conveys precise, well, not precisely, because it's difficult to be precise, but conveys the full scope as has been put to me of his conduct in defending the racketeering charges. Certainly the finalization of the answering affidavit is an important aspect of that conduct, and is the one that is referred to in this subparagraph or 3.1.1.3. And I hear Advocate Mukaitobi saying that he doesn't want the steps, but it relates to the scope. That's the conduct broadly. And so to that extent, I can agree that it relates to that conduct.
Yes, now, thank you. Now, the charge is even more limited because it is about the finalization of the answering affidavit. Now, you have other things you wish to add to the charge, but they're not in the charge.
So as I mentioned earlier, I have testified about what I know and what I've experienced and what I've found in this process. And I'm not attempting to add anything. I am giving evidence. And in my view, it is because of the Chapeau 3.1, what I'm saying is admissible and should be considered, because these sub-paragraphs, if you want to call it that, 3.1.125, are not limited. And so I'm giving evidence about what I know and what I've experienced, and that's all I can do here.
Advocate Batoy, you are still not answering my question. The question is straightforward. That charge, I know the word charge is a strong word, but it was introduced, thankfully for all of us, by the chair, refers to the finalization of the answering affidavit. Doesn't refer to these other steps you are talking about.
But it includes them.
Where does 3.1.1.3 include them?
I said the chapeau includes them.
Yes. So the preamble,
Yes, 3.1.
yes. Now, we are still to look at what the draft was. Because it seems to me that the simplest thing would have been to tell Mr. Chauke that you are accused of preparing the answering affidavit. You are also accused of the following preparatory steps, because that is all information that was within your knowledge when these charges were prepared. Is that not correct?
It was within my knowledge, that's correct.
Yes. And now, why don't you include it in 3.1.1.3?
If we wanted to include everything, we would have had to include Dr. Broughton's bundle as the charge sheet, because it has lots of conduct of Advocate Chauke that would fit into some of these, like his role in preparing the answering affidavit.
But Advocate Batohi, I'm asking you about one aspect. I've not even come close to Dr. Broughton. I'm asking you about the preparatory steps that you have sought to add to 3.1.1.3. Why were they not reflected? It would have been one sentence in 3.1.1.3.
I can't answer why it was not included, but that's
Yes.
my evidence.
Thank you very much. Then I said to you that there was a further aspect of this charge when in my analysis, I couldn't understand. It talks at the end, in the last line, with racketeering charges against the accused. Now, on the one hand, it may appear to refer to all of the accused. And on the other, it may appear to refer only to Major General Boyson. Does it refer to Major General Boyson only, or does it refer to all of the accused?
I'm looking at the context of this charge, and well, for want of a better word, and the way it's framed in order to answer your question. It says here, he finalized the answering affidavit of the then acting NDPP Advocate Jiba in the Boyson review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, given that it is referring to the Boyson review application, my interpretation of that would be that it refers to Boyson alone.
All right, so unlike 3.1.1.1, which you said refers to all of the accused, 3.1.1.1.3 refers only to Major General Boyson.
Yes, that is correct.
Yes. And can you explain why it did not say against Major General Boyson?
I can't.
Because that again would have been a very simple insertion. You would accept that?
To the extent that it's relevant, it would be a simple insertion. But
Well-
it doesn't make a difference to what's said there.
Well, okay, let's talk about the relevance. It's clearly relevant to tell Mr. Advocate Chauke what the scope of the allegation is. And if the scope is limited to Major General Boyson, it's relevant to tell him that. Wouldn't you accept that?
Well, in this context, it is telling him that.
Yes. Now, if you look at 3.1.1.4,
Marcel, before you go there, and Advocate Batoyi, this is just a clarity seeking exercise on my part. Whilst we are still on 3.1.1.3, look at paragraph 142 of your affidavit. It's on page 60.
Mhm.
This paragraph refers to the unlawful action on the part of Advocate Chauke as the de facto DPP. You remember?
Mhm.
That
I
was
do.
that was your evidence. And now, when we unpack this allegation or this statement on your part relating to the unlawfulness or the alleged unlawfulness on his part, I suppose we should then go to the terms of reference 3.1.1.3 that we've just been talking about, and try to relate it to what you allege to be an unlawful action on his part. If one were to look at 3.1.1.3 regarding his having finalized or settled the answering affidavit on behalf of Advocate Jiba to defend the review application, will that per se constitute an unlawful action? Put differently, will the mere settling of an affidavit on behalf of the head of the NPA in itself constitute an unlawful action? Because what I seek to understand is precisely what is this unlawfulness that you are referring to. Is my question clear to you?
Reasonably, Chairperson.
I beg your pardon?
Reasonably clear. I will try to answer it. Chairperson, the unlawfulness of Advocate Chauke's conduct is all actions he took in the context of this matter, particularly relating to prosecutorial decisions as the de facto DPP in this matter. Those actions that he would have taken in that context would be unlawful. This particular act of finalizing an affidavit, generally, it would not be, in fact, DPPs would be involved in such actions for a national director to settle affidavits. But if in the settling of the affidavit, you are actually taking a prosecutorial decision to appeal a matter or to recommend to the NDPP that this matter be appealed on the basis of the contents, or not appealed, the matter be opposed on the basis of what is contained in the answering affidavit, then in my view, that amounts to his role as the de facto DPP and would in fact also be something that a decision a prosecutor would take in terms of opposing an application. And in that sense, it would be unlawful conduct.
It's kind of a long answer, but I just want to ascertain from you whether that single act in relation to 3.1.3 of the terms of reference specifically reflected as I quote, he finalized the answering affidavit of the then acting National Director of the Public Prosecutions, Advocate Nomgcobo Jiba, in the Boyson's review proceedings. It is that just to focus on, understand whether the allegation of unlawfulness in your affidavit at paragraph 142 covers that limited aspect of the terms of reference that I have just read to you. Let's not talk about anything else because I assume they will deal with further decision. I just want to clarify in my mind whether this act of settling an answering affidavit on behalf of the head of the NPA in itself constitute an unlawful action.
Chairperson, my answer to that is yes, it does. For the following reason, that a decision to oppose a review application is a prosecutorial decision. And that decision to oppose was taken by Advocate Chauke and supported by him as reflected in the contents of the affidavit that he settled.
And that affidavit that he settled is not his affidavit. It is under the signature of the head of the NPA.
That's correct.
Who will take the rap for whatever is in that affidavit, irrespective of who settled it?
That's correct.
Am I correct?
Well, that's correct. She will take the rap for it to the extent that, there's anything unlawful about that. If there is.
No. I just want to ascertain from you as to, even if somebody drafts something for you as the head of the NPA and you append your signature ultimately on that very document, it is you who's going to be accountable for whatever appears in the document that you sign.
Yes, Chairperson, to the extent with regard to the conduct of the signatory to an affidavit, you will be, but here we're looking at the conduct of Advocate Chauke before that in taking a prosecutorial decision.
I'm not asking about that, Counsel. I'm just talking about a simple thing in relation to signature and the impact of your signature on a document, irrespective of who drafted it, that you finally apply your mind to the content of the document and decide if you align yourself with its content. That's what I'm trying to ascertain with you. That finally, irrespective of who proposed, who advised, who drafted it, you are the final decision maker in relation to the content of this very document. That's what I'm just trying to ascertain.
That's correct, Chairperson.
Yes, thank you.
Thank you, Chair. Advocate Batoy, I am still on 3.1.1.4. And perhaps to close off on the discussion you've had with the Chair, I understood that you accepted that the entirety of 3.1.1 is about racketeering. And you also accepted that racketeering is within the exclusive power of the NDPP. Was I correct?
Sorry, what section? 3.1 point?
Point 1, all of those sub-paragraphs are about racketeering.
That's correct.
And racketeering is within the exclusive power of the NDPP.
That is correct.
Now, I'll go through now to 3.1.1.4, but just to close off on what the chair has asked you. There is no charge that I have seen here that accuses Advocate Chauke of acting outside of his jurisdiction, particularly on racketeering, which is the exclusive power of the NDPP.
I need to check this, Chairperson, if you give me a minute. Yes, there's nothing here that says he acted outside of his jurisdiction.
Thank you. Can we then move on to 3.1.1.4? And again, just to remind you, the exercise I'm doing now is to analyze the charge to ascertain precisely what is the scope. It says you instituted, I'm inserting you instituted, an appeal against the judgment of Judge Govan in the review case of Boysen versus acting NDPP without the approval of the National Director of Public Prosecutions, Mr. Mxolisi Nxasana, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused, and no justification for lodging an appeal against the judgment. Now, you have not referred us to any record indicating the decision by Mr. Chauke to institute the appeal. And perhaps you can come back on that on Thursday when you go through the record.
I can try to deal with it now.
All right, carry on.
To the extent that I can. I certainly won't have time to look at the record between now and Thursday. The issue is that the matter of the appeal against the Govan judgment, certainly Mr. Nxasana, if he is called, will be able to give clarity on this. But my understanding is that I think Advocate Chauke's response to the president might help us in this regard. If I could just have a look at that. Do we have that letter? If you'll bear with me, Chairperson, I just think there's something about this in this letter. Paragraph 42 deals with his response to the president, Chairperson. If I could just read it, it might help me. Should I read it aloud, Chairperson, or just to myself?
You may, ma'am.
Thank you, Chairperson. Mr. President, following the judgment from the High Court, the prosecution team received a recommendation from Holders SC, who represented the NPA in the review application, that there were good prospects of success in the appeal. Advocate Holders expressed a concern that considering that the days for the lodgement of the application for leave to appeal were soon to expire, it would be advisable to provisionally lodge the application pending the final authorization from the NDPP, so as to avoid the compilation of having to seek condemnation if the NDPP were to decide to pursue the appeal, and that if the NDPP decided against the appeal, it would simply be withdrawn. I was present at the meeting at which this was discussed. My reading of this then would be that Advocate Chauke decided to, as it says, provisionally or advise or instruct, I should say, because it would be the instruction, Advocate Hodes would only act on the instruction of the NPA, to provisionally lodge the application pending authorization from the NDPP, which means that at that point, there was no authorization from the NDPP to do this. But Advocate Chauke indicates reasons why they needed to move quickly because of the DS. And so in my reading of that, it would be his instructing Advocate Hodes to institute the appeal. Yes, thank you, Chairperson. That's my response.
Well, I honestly do not understand what you have just said. My question is simple. You have not referred us to a single document in which it is recorded that it was Advocate Chauke's decision to institute an appeal. Paragraph 42 does not say that.
In my view, it does.
Show me the words there which says it was my decision to institute the appeal.
It's my reading of that section that my conclusion, well, my reading of this is that Advocate Chauke decided to advise Advocate Hodes to provisionally lodge the application, which in my view is instituting the appeal.
So-
But of course, he says pending the authorization of the NDPP.
So even though the paragraph does not say, I instructed the institution of the appeal, you decided to read it as meaning that that is what it says.
From the evidence, we know that the appeal was in fact lodged.
That is not the issue. The issue is whose decision was it? You have charged Mr. Chauke as the person who made the decision. I am looking to see the factual basis for the charge, which presumably you would have had even before Mr. Chauke made representations to the president.
The factual basis is that Advocate Chauke, as the de facto DPP in this matter, met with Advocate Hodes, and after that meeting, there was an appeal that was lodged. And in my reading of that, it was on his instructions, because if you read further, he then briefed on paragraph 40. Well, at paragraph 43, he says he briefed Dr. Amaite on the recommendation we had received from counsel. He expected, I'm paraphrasing, Dr. Amaite to brief the NDPP. That is my reading of the evidence.
Now, Advocate Batoy, please help us here. This paragraph 42 and 43 are things that happen way after you have recommended to the minister that Mr. Chauke must be charged for bringing the appeal. At that stage, when you took the decision, you must have had a factual basis. Point us to it.
It's in the evidence bundle, Dr. Broughton's affidavit and the evidence. My recollection in summary, as I mentioned, and I will mention again, is that Advocate Chauke, if I'm not mistaken, there was a prosecution memorandum that was drafted in support of the appeal. He met with Advocate Hodes, and thereafter there was an appeal that was lodged, without the NDPP's approval. In my understanding of that, Advocate Hodes would have acted on the instructions of Advocate Chauke.
Yes. All right. So as matters stand, you are relying exclusively on the report of Dr. Broughton. You are not relying on any objective memorandum signed at the time to instruct the institution of the appeal.
Dr. Broughton's report has the evidence attached to it. So I am talking about his report, which has a comprehensive dossier of evidence, which is about a lever arch, maybe more than that. I think it's a lever arch and a half full of the evidence. So I looked at documents and the evidence and not just what Dr. Broughton said.
All right. So as I understand then, again, to try and define the scope of the charge, you are saying if we read the report of Dr. Broughton, we will find there a document prepared by Advocate Chauke which instructs the lodgement of the leave to appeal.
It's not what I said.
Well, I thought that's what we've been discussing for the last 5 minutes.
We have been.
So then, when I asked you to exclude the report to the minister because it came after your decision, and you said, well, look at Dr. Broughton. And I'm now asking you whether it is your evidence that Dr. Broughton has attached to his report documentary proof of an instruction from Mr. Chauke. Are we going to find it or not? Very simple.
You will not find a document of that nature.
Yes, all right, thank you very much. Now, I just want to go to the analysis of 3.1.1.5. It is alleged in this charge that you, Mr. Chauke, attempted to have racketeering charges against Major General Boyson and members of the Cato Manor unit reinstated by the then National Director of Public Prosecutions, Mr. Nxasan, notwithstanding that there was no evidence justifying the institution of racketeering against the accused. Now, I have 3 questions. The first is whether or not this charge is limited to racketeering or includes the independent subsidiary offenses.
It's limited to racketeering in my understanding.
Thank you. The second is whether or not this charge suggests that there was no case of racketeering for everyone, not just Major General Boyson.
It does. Well, let me read that quickly before I respond so fast. It does.
Yes. The third one is, on what basis do you say it was Advocate Chauke who attempted to have the charges reinstated? Just show me the document where he tried to do that.
I'm trying to recall the evidence of what Advocate Chauke did after Advocate Nxasana was appointed. And I can't recall it at the moment, what exactly the evidence is in that regard.
You can't recall.
I can't recall what the evidence is in this regard.
Yes, I understand. But it's unfair to ask you to recall all of the evidence.
Thank you very
But
much. I appreciate that.
I can ask you to recall at least one thing, which is, on what basis did you suggest that it was Advocate Chauke who attempted to reinstate the charges? Surely you must recall that.
I can't recall what his conduct was at that point regarding what happened when, but for the appeal aspect. I'm not sure what more Advocate Chauke did. What I do know is Mr. Ngasana at some point asked Advocate Chauke, after he raised the issue of him exercising, I'm not sure how it was exactly put, but the fact that Advocate Chauke had no jurisdiction in KZN, and he then said that this matter must be dealt with by Advocate Noko. That's what I recall. So I can't, besides that, I don't know what exactly he would have done to have these charges reinstated after Mr. Ngasana was appointed.
Yes. Because it seems
If
to
there's
me,
any evidence, it will speak for itself. As I said, I'm testifying about things that happened when I was not even there. So it's about the evidence that should speak and not my trying to recall what the evidence was. That's what the idea of this fact-finding is.
you see, Advocate Batoy, it seems there are two independent acts that are being conflated. The first one is whether there was ever any attempt to bring life to these charges under Advocate Ngasana. The second is whether Advocate Chauke was involved at all.
Mhm.
As I understand, you can't help us on either.
I can't, but hopefully the evidence leader can look into this. And if there's any evidence that needs to be led, any facts that needs to be brought to the attention of this panel, it will be done. If there isn't anything, that's the position.
Can you recall when Advocate Ngasana assumed the office of NDPP?
No.
If you go to LO 00886,
Advocate Nkoitobi.
thank you, Madam Chair.
Please repeat that.
LO 00886.
Mhm.
There is an email of the 11th of April 2014 at 2:51 p.m.
Mhm.
from Mr. Chauke to Dr. Ramaite. Can you see it?
See one at 3:20 to
Yes, there is
51
one below that.
to Dr. Ramaite.
Yes.
Yes, I see that,
Now,
251.
Mr. Chauke says, I refer you to the comments and reservations of both the NDPP and yourself regarding my involvement in the Cato Manor matter. I refer also to a subsequent meeting that I held with the NDPP on 8 April 2014. I hereby confirm that I will no longer take part in any way regarding the management and prosecution of this matter. I have accordingly informed the team leader, Advocate Mayema, and the DPP KZN Advocate Noko. That is dated the 11th of April 2014, referencing a meeting with Advocate Ngasana on the 8th of April 2014, where Mr. Chauke says he will no longer participate in any manner whatsoever on Cato Manor. So surely your evidence on 3.1.1.5 must show us that after this date, Advocate Chauke attempted to have the racketeering charges reinstated.
As I said, I'm not the only witness in this matter. I don't know what the evidence is going to show.
Well,
Please, repeat the question, and if you can just try maybe to confine yourself to the question that has been asked. If you know, yes. If you don't know, no. So that we obviously know your stance about this question.
Yes.
Because I'm not sure how you are answering it, Advocate Batoi. Please repeat the question.
Thank you, Madam Chair. Advocate Batoi, I referred you to the email of the 11th of April 2014 at 2:51 p.m., written by Advocate Chauke to Dr. Ramaite, in which Advocate Chauke says, bearing in mind the discomfort of the NDPP, which was expressed in the meeting of the 8th of April 2014, he withdrew from involvement in any manner on the Cato Mano case. Now the question is, surely to establish 3.1.1.5, you would need to produce evidence that after the date of the 8th of April 2014, Advocate Chauke attempted to have the charges reinstated.
My response to that is I don't need to produce the evidence leader needs to. I will testify about what I know, what evidence there is. I don't know what happened after that.
All right, let me not say you need to. Let me ask you, do you have the evidence?
As I sit here, I don't have any evidence.
All right, thank you very much. Could I then try and do an analysis of the following charge?
Just for clarity, and it is the evidence in relation to the alleged attempt to
Yes.
reinstitute
Yes, Madam Chair.
the
Correct.
racketeering charges.
Yes, correct. Now, could I also just try to analyze 3.1.2? That is the Mr. Mdluli charge. Now, could I just understand the scope of this charge again? Now, I'm going to reference a discussion that you had with panel member Ramachakha. When she asked you about the charge, particularly with the use of the word "in that" as suggesting a limitation of the scope of the charge, you said in your response, maybe these terms of reference must be amended. Can you explain why you said that?
I can't remember the context of that particular question.
You can't remember.
Let me read this and see try to gauge what I might have meant by that. To the extent that this is not complete in terms of the conduct of Advocate Chauke's that we complain of, I would have possibly meant that it should be amended to include his conduct not just at the point of withdrawal of the charges initially and submitting it to an inquest, but also his conduct after that, after the inquest hearings, not hearings, yeah, they were hearings, after the inquest process was completed, his conduct his conduct in coming to a conclusion that the magistrate found no evidence implicating General Mdluli when that was incorrect. The magistrate's findings were confusing and contradictory. So in that regard, Advocate Chauke at that point ought to have reconsidered the matter given two things. One is that the prosecution team said there was strong evidence against General Mdluli. The fact that the magistrate's findings were confusing, and also the fact that the representations of General Mdluli was a fanciful conspiracy. So that's the next point of decision making. Thereafter, Advocate Chauke's conduct after the Mdluli, the Murphy judgment, when Judge Murphy was very critical of the conduct of Advocate Chauke, and
And I just want to put a proposition to you for your comment. As you know, because Mr. Chauke has made representations, he says he was uncertain about the strength of the evidence. Is it your case that a prosecutor does not need to be certain about the strength of the evidence?
that's not my case. That's what Advocate Chauke says.
No, I understand that his justification is that he was uncertain. I'm asking you why he is being charged. Is he being charged because you are saying a prosecutor does not need to be certain about the evidence before they enroll a matter.
That is not the reason why he's being charged.
But what is your answer to my question? Are you saying that the prosecutor does or does not need to be certain about the evidence before they put the matter for a charge?
A prosecutor must be certain of the evidence.
Yes. Now,
Perhaps, Counsel Advocate Batoy, are you suggesting, as regards the evidence that is to be presented at the trial, at the state of charging, a prosecutor must be certain of all the evidence that needs to be presented to prove the charge? Is my understanding correct? Or should there be merely a prima facie evidence to institute that charge? If you can clarify that to me, or clarify your answer to Advocate Nkweto.
Person, yes, thank you for that question. I'm not suggesting that at the point, because at that point could in fact be prima facie evidence. It could be a situation where a person has been charged because there's sufficient evidence to charge, but at that point you should be certain of that level, whether it's prima facie. You must be certain that you have sufficient basis to charge the accused at that point. It doesn't mean that it will be all the evidence, because investigations could continue and more evidence could be gathered. So, but I think the question that I was answering to Advocate Nkaitobi was slightly different. My understanding of his question is that if a prosecutor, well, put conversely, is uncertain of the evidence, should you charge? And my answer to that was no, you should not.
Thank you.
thank you. Well, it seems you've given inconsistent answers to my question and the chairperson's question, which are effectively the same question. Maybe let me give you a chance to clarify. What should a prosecutor be certain about? What is he allowed to be uncertain about before he makes a decision to charge?
Well, firstly, let me say I have not given inconsistent answers. I've answered different questions. And to your question, and the record will show, we can go back. Your question was, put conversely, whether a prosecutor should enroll a case if he is not certain of the evidence. And I said, no, that should not be the case. The chairperson's question went further and asked whether at the stage of charging, a prosecutor must be certain of all the evidence, and whether shouldn't there be a prima facie evidence. And my answer to that was that when a prosecutor charges, they need to be certain that at that point, it meets the standard that is required for the enrollment of a matter. That could be either at the level of prima facie evidence, which is completely in order for you to enroll it, but that doesn't mean you are certain of all the evidence, because there could be evidence that is obtained after that. So I hope I'm clarifying. In my view, I'm not giving inconsistent answers because the questions were slightly different.
Yes, thank you very much. Now, could I also ask you about the issues in relation to the Mr. Mdluli matter? Is it correct that you relied exclusively on the memorandum by Advocate Gathali SC?
That's not correct.
What else did you rely on?
prior to me asking for his opinion, I had received the opinion of Advocate Nalane, who recommended that this be one of the matters that be included in any referral to the president. I had Advocate Chauke's response to that in his in the form of Advocate Maineche's opinion. I think I must just look at my letter that I sent to Advocate Chauke before I respond further, to make sure that I am clear that my recollection of what happened a couple of years ago is correct. The letter to, is it in here? Okay. Might be an attachment to my affidavit, Chairperson.
Is it when you requested Advocate Chauke to present further information?
On the 5 matters.
I beg your pardon, may I finish?
My apologies.
In a document attached to your affidavit, SB6 at 240, and I'm not sure whether this is a document where you requested for further information relating to the decision made by you as the DPP Gauteng Johannesburg, and Advocate Chauke then responded from SB 6241. Is that a document?
Yes, I think it's SB5, Chairperson. Just check that now.
You see, the one that I'm referring you to, just let's deal with the one that I'm referring you to first. That one is SB 6241, attached to your affidavit. Those additional documents that you filed of record, and in the first heading, he deals with the Richard Mdluli murder case and the related charges. Is that the document you wish to refer to?
No, Chairperson.
Okay, let's look at SB 5 that you referred us to then. Only SB 5 that I have here is your request to Advocate Chauke, SB 5231,
That's correct.
which then culminated in his response at SB 6.
That's correct.
The SB 5, is that the one that you're looking at, your request to him?
That's correct.
Yes.
I'm looking at paragraph 2 on page 232. So I had access to documentation in a file. I had a 2.2, there was a decision, a court decision. In fact, there would have been all the decisions. It would have been the Judge Murphy decision as well as the SCA Brunt decision, as I set out. So I would have had also Advocate Chauke's response to this matter in SB 6. I think that's all the information I would have had. That's the information I would have had before the opinion from Advocate Hali.
Yeah, we noticed that it's now past 12 o'clock.
Going
It's 12:03.
Yeah, it's past 12 o'clock. Okay.
Thank you for reminding us, because I cannot be late for my appointment.
I had actually thought that maybe I should find out, Council, whether you are ending it up at General Mdluli's point, the terms of reference 3.2, or you want to exhaust this question before we step out?
Chairperson, may I please comment on that? Well, let's hear what Advocate Mugaitobi says first.
That's fair, because I'm asking him the question, not yourself. Shouldn't you wrap up, or you want to tie it up?
Madam Chair, I can stop now, but it's not a convenient place, but the agreement was that we would cut off at 12, so I should stick to that.
Advocate Batoi, as Council mentions, it may not be a very convenient point to leave the questions hanging, but given your request, we will, I see you anticipate what I'm going to say. We'll definitely adjourn, because we bear in mind your earlier request that you be afforded an opportunity to go and attend to your personal matter.
Thank you, Chairperson.
So you need not change your face, because.
Thank you, Chairperson. I'm only human.
We are going to adjourn to keep our undertaking to enable you, as per your request, to adjourn now until Thursday morning. To all concerned, Council, Advocate Batoi, we will adjourn and reconvene on Thursday morning, the 11th at 9 o'clock. In the meantime, we will request that we be finished with the document that was to be provided earlier, so that when we reconvene, we would have had a look at it. Please instruct your team to file that document or give us copies.
Thank you. I'm indebted to the panel.
We will adjourn until the 11th of December, Thursday at 9 o'clock.